It's my great pleasure to introduce our third session dealing with the legal aspects of clearing munitions from the sea. In talking about legal aspects, who would we want to lead us through that discussion? Well, what better than a lawyer specialized in the fields of administrative and European law, someone who has trained as a reserve officer in the German Navy on a minesweeper, I am told. Ladies and gentlemen, we have with us a representative of the Walther-Schücking-Institute for International Law here at Kiel University. I give you Dr. Moritz von Rochow.
Good afternoon, Minister. Good afternoon, ladies and gentlemen. It's a real honor and a pleasure for me to be here, as I left school in 2004, going on a minesweeper, and now after 17 years, having to deal again with the cleaning and clearance of munitions. And I regard law as being a tool for politics and for science, and that's why I'm pretty happy that we have two experts on this field who can elaborate on these tools, how to implement and how to evade obstacles in order to get the common goal achieved, to clear the Baltic seas at first and the oceans at the end. So I'm welcoming you as the audience, but I'm especially welcoming our speakers, Mark Wernicke, who works for the Kampfmittelräumdienst, Schleswig-Holstein, which is the ordnance clearance office of the land Schleswig-Holstein. Mark, I would like you to have a seat here. And our second speaker today will be Mark Dawson, whom I'm particularly happy to see him here, as he took the challenge to use the Deutsche Bahn, despite of the strike, to come all over from Groningen to Kiel to talk to us about the issues of international law. Welcome, Mark. Please take a seat.
That's too much.
So what are we going to do in our 1.5 hours? Both of the speakers have at first 20 minutes for the presentation, which allows us to go really deep into the topic. So we have two really qualified speakers talking 20 minutes about their subject. And then we will have time for your questions and also for the questions coming from the online audience. The online audience, welcome to you, is obviously free to ask their question in advance, and then they will be dealt with after the 40 minutes of our speakers. When we talk about law, we have to see that we have 4 layers of law with which we have to deal. The first layer on the very top is the international law, which governs the relations between the states. And then we come down to national law, which in Germany is a bit more complicated as we are a federal state, so we have the federal law from Berlin. And then we have 16 laws of the 16 Länder, which also have some words to say with regard to ordnance clearance. And then, as responsibilities always trickle down, there might be obligations of private entities, for example, who plan to build some infrastructure, some structures in the sea, and probably also have some responsibilities to bear when they find ammunition in the sea. So we start with the international law, and the international law has several sources, which is treaty law on the basis. The most important source is UNCLOS, the United Nations Convention on the Law of the Sea, 1982 in Montego Bay in Jamaica. Then there is customary law, and then there are the general principles. And as a subsidiary mean for the determination of the rules of law, there exist the teachings of the most highly qualified publicists. And I'm very happy that we have one of those most highly qualified publicists here sitting with us. Applause for Grant Dawson, please, who will talk to us about international law. He spent the last 7 years at the Organization for the Prohibition of Chemical Weapons in The Hague, taking care for a world without chemical weapons. Since May, he is now devoting himself to normal ammunition dumped in the seas, writing his PhD in international environmental law at the University of Groningen in the Netherlands. And beside that, he is a legal officer at the Special Tribunal for the Lebanon. Grant Dawson is a qualified lawyer who studied at the Columbia University in New York and Georgetown University in Washington, D.C., and his latest publications focus mainly on the aspects of human mobility and chemical weapons. Grant, the floor is yours.
I'm very grateful for that very kind introduction, and I'm deeply grateful to be here. Since I have this on my head, I'm free, I think, from the podium. So the task that I've been given is to talk to you about the international law aspects of the topic that we're all here to discuss. I'm extremely grateful to be sharing the podium with my colleague here, who will talk to you about the domestic German aspects of the law. So we're going to talk a little bit about the absence of norms after World War II, and then hard international law, customary international law, and finally, the topic that everyone's really interested in, responsibility and liability. Just a note about hard international law. There's hard law and soft law, and the hard law is the one that binds states to mandatory obligations, and the soft law is more guidelines and recommendations. So these are images that everyone will probably be very familiar with. The first one is from the Potsdam Conference in 1945. The second one is the leaders of the Allied powers who have agreed to the Potsdam Communique, which is sometimes called the Potsdam Agreement of 1945, which regulated a bunch of aspects about how post-war Germany was going to be administered. And then we have this picture you've all seen many times before of mustard canisters being dumped into the Atlantic Ocean. And then these are actually conventional munitions in the last image off the coast of Nova Scotia on the seabed. I wanted to talk about the Potsdam Agreement very briefly because I think there's some, this agreement comes up quite a bit in the literature, not only the legal literature, but also the scientific literature. And when I looked at this agreement, it's not what you expect to see when you actually read the agreement. And I had to read it several times to actually figure out what provision is relevant to submerged munitions. And the best I could come up with is Section 2A, which I've quoted here. All arms, ammunition, and implements of war, and all specialized facilities for their production shall be held at the disposal of the Allies or destroyed. Now, the backdrop of this agreement is we're talking about Nazi munitions. We're not talking about all munitions from all sides. So that's the first point I wanted to make, that the Potsdam Agreement, it's talking about Nazi munitions, not all munitions. And the second is, this is as specific as it gets, or destroyed. It didn't say how that these munitions were to be destroyed. So the Potsdam Agreement itself is quite general. Subsequent to the Potsdam Agreement, you had the Continental Committee on Dumping, and that was the body that decided to dump the Nazi munitions into the seas and oceans. So the Potsdam Agreement is important in that it was the first agreement to positively authorize the dumping of munitions into bodies of water, but it is limited. But it has been interpreted expansively at the time. And more important than the Potsdam Agreement is the fact that for the 40s and the 50s and most of the 60s, you had an absence of prohibitions on dumping. And it's the absence that is really legally relevant for this specific situation, as we'll see later when we talk about responsibility and liability. So now I wanted to talk about the hard international law that comes from treaties, agreements that have been voluntarily entered into by states. So these are all obligations that we're going to look at where states have positively decided to bind themselves to certain norms. No one forced it on them. You have, in the late 60s and the early 70s, you have the rise of international environmental law and domestic international law. And some of the domestic statutes actually preceded the international agreements. And one of them that I wanted to point out was the 1972 London Convention, which entered into force in 1975. And at articles that you can see here, it prohibits the dumping of certain materials on Annex 1 into any body of water. And it specifically mentions in paragraph 7 of Annex 1, biological and chemical weapons. So it's a very specific mention that this is not the way to destroy chemical weapons, and also munitions are not to be dumped in the sea. But prior to that, and relevant domestic statutes, you had this absence of norms prohibiting the dumping. I also wanted to mention the Helsinki Convention, which is relevant, of course, to the Baltic Sea. And it was updated in 1992, and the update went into force in 2000, but the basic norms on the protection of the marine environment were in force as of 1980, when the first Helsinki Convention went into force. At Article 3, states must take measures to prevent and abate pollution and protect and enhance the marine environment. These are norms that the states took upon themselves voluntarily. And Article 9 prohibits dumping and mirrors the London Convention. Our esteemed moderator mentioned UNCLOS, which is of central importance. UNCLOS is, of course, the umbrella treaty for the law of the sea, and then you have the regional seas conventions like the Helsinki Convention and other bilateral and sub-regional agreements. UNCLOS is very important for a number of respects, and I'm not just throwing articles at you for no reason. I purposefully put some specifics here because I want to demonstrate with specificity that there's real hard law out there that binds states and sub-state actors. And here it is. These are super long articles, which I've condensed into just a very short little paraphrase. Article 92 is the general obligation to protect and preserve the marine environment. And thank you very much for reminding me, Professor, that it's an obligation of conduct, not of results. You have to have due diligence when you are undertaking offshore activities. Article 193, states may exploit resources, but only in accordance with the duty to protect and preserve. So you can use the oceans and the seabed, but when you're doing it, you're obligated to not destroy the marine environment. Article 194 is of particular relevance to submerged munitions because states must take all measures necessary to prevent, reduce, and control pollution of the marine environment from any source. This is going to become very relevant when we talk about some of the customary international law principles, and especially responsibility and liability, because this is a very strong provision, Article 194, but there's a principle in international law that treaties, unless they expressly so state, and they almost never do not reach back in time. They only go from the time forward. So, when we say that states must take all necessary measures to prevent, reduce, control pollution of the marine environment from any source, what about legal dumping in the past that's causing damage now? Question mark, and I'll leave that as a question right now. And then finally, in UNCLOS, we have Article 210, states must adopt domestic laws to prevent, reduce, and control marine pollution. This is called a rule of reference. So this is a general obligation telling states, you can't just rely on these general principles, you must promulgate domestic laws to actually put these obligations into practice. And this is where we'll be hearing from our domestic German law expert later. we're now going to talk about customary international law. Customary international law is, even among legal scholars, it's the source of raging debate, and it's misunderstood very often. And I find it actually a difficult concept. Customary international law can be seen as either law that is not written down, but states have to follow anyway, or law in a treaty that binds states that are not members of the treaty. So sometimes states get together and they put these basic norms into treaties, and they abide by them, and they use it to regulate their actions. And when they do that, and it becomes so ingrained in the law and the culture and the policy, it actually gets this level of customary international law, and it binds legally other states who have not signed up to the treaty. For example, UNCLOS, there are a lot of states, some very important states, that are not members of UNCLOS, but are still bound by the provisions of UNCLOS, because Part 12, the environmental provisions of UNCLOS, have reached this customary international law status. So I want to talk about 3 of these binding norms, and the first is the principle of prevention. This is the obligation to abstain from activity that causes transboundary harm. You are not allowed to use your territory to do something that is going to cause the territory of another state to be damaged. And you also can't use your territory to do something to damage someone else's territory and then compensate them later. You have to prevent the harm in the first place, and you're not allowed to cause it and then cure it later. I think this is we've heard a lot today. I was very excited to hear so much discussion about the oil, gas, mineral extraction, wind farms, pipelines. I'm not sure if I heard aquaculture yet, but this is something that's going to become also a factor as we start to use the coastlines to generate food supply. But I've talked to many different people in this field, and I'm very happy to be corrected if I'm wrong during the discussion, but I've talked to people who are laying pipelines, who are doing the wind farm installations, and they say, yes, we had to put in 200 million into our bid to clean the area of all the munitions. And I said, wow, that's great, 200 million to clear the area of munitions. That sounds fantastic. And he said, well, yeah, what that really means is we pushed it aside. That's how we cleared the area of munitions. So that's what I've been told by several different sources of people who are doing it, but I'd be very happy to be corrected on that if I'm wrong. So this raises the question of prevention. Are you complying with the principle of prevention if your way of remediating an area for a wind farm is simply to push it to the side? I think you probably know what my answer to the question would be. I don't think that's consistent. I love the euphemism. It's called redumping. First of all, it's called clearing, and then if you're more honest, it's called redumping, which is nice. I think it's dumping. Legally, I think it's dumping. And so you are violating the London Convention, and you're violating UNCLOS, and you're violating customary international law. The next customary international law principle is the principle of precaution. I heard it's so great to be at a conference with scientists, and well, I'm kind of the odd person out, but it's nice to be with scientists and to hear the debates about what is proved, what is not proved, and the level of proof. As a non-scientist layperson, what I'm hearing is there is now empirical scientific proof that the submerged munitions are adversely impact the marine environment. I know there's nuances to it, but that's what I'm hearing. And so I think the precautionary principle is less relevant to the Baltic due to all of the work that has been done by you all in the audience today. However, it is still very applicable to other areas outside the Baltic where there hasn't been this intensive research over the last couple of decades. And you all know what the precautionary principle is. It's a principle that it's a legal principle, but you hear it a lot in non-legal circles. And it's a very simple one. It's when you don't know if something is going to harm the environment, you're not sure, you don't do it. You err on the side of caution, and you take precaution. And this is something that's a customary international law principle that all the states in the world are bound to follow, and all the coastal states of the Baltic. The last customary international law principle I wanted to discuss is the principle of cooperation. And again, we've been talking about cooperation a lot, but my job is to tell you it's not just a political idea. It is a legal obligation of states to cooperate with each other in situations where they are taking actions that can impact the environment. And so this is especially the case when you are dealing with an issue that could cause effects across an international boundary. And like with the air and the climate change, the oceans and submerged munitions are the quintessential transboundary issue. The water doesn't stay in one place. I wanted to mention that the UN General Assembly, they had their Law of the Seas resolution recently, but back in 2013, there was a very important resolution of the General Assembly dealing with submerged chemical munitions, where the UN General Assembly called for cooperation and further scientific research, and it sought to deal with sea-dumped chemical weapons as toxic waste. This was significant legally because under the Chemical Weapons Convention, a chemical munition before 1925 can be dealt with as toxic waste, but the General Assembly is taking a different approach to that and is advocating that all submerged chemical weapons, despite their dates, should be dealt with as toxic waste. So they're carving out the munitions that are under the ocean, and they're trying to deal with it from an environmental perspective instead of from a disarmament perspective. Responsibility and liability. So as I've tried to demonstrate, talking about customary international law and hard law from the Helsinki Convention and UNCLOS and the London Convention, there is a legal responsibility of states to clean up munitions in the Baltic Sea. There's no debate about that. And, but the question of responsibility is different from the question of liability. These are two different things. Liability is about money. And the International Law Commission has adopted the draft articles on responsibility of states for internationally wrongful acts. And Articles 1 and 2, the foundational articles of this very authoritative legal document from the UN International Law Commission, it says that the act or omission must have constituted a breach of a state's international obligation. So a state will be responsible if this condition is fulfilled. So this gets us back to the temporal aspect of the problem. There's a very strong argument that when much of this material was put into the seas and the oceans, there were no specific prohibitions on doing so. So, does that fit this description? Is it a breach of the state's international obligation? Or do we look at this in the present day, and we look at the positive obligations under UNCLOS and other articles for states to protect and preserve the marine environment, and some of the regional treaties say restore the marine environment? Do we look at it right now and say there's a positive obligation to do that, nothing is being done, so that's a breach of your state's international obligation? But even if you say yes to that second question, you're still in the area of responsibility and not liability. And there's very strong authority at the Organization for the Prohibition of Chemical Weapons, which is the treaty body of the Chemical Weapons Convention, and at the United Nations, the resolution that I talked about a moment ago, that the states want to deal with this in taking the approach of cooperation. They do not want to deal with this with the approach of liability. And even if you were to try to approach this from a liability perspective, the causality about the dumping and the harm that's being caused now is going to be very attenuated by the incomplete historical record of the dumping and by the by the passage of time and the movement of the ocean, which has moved the munitions all over the place. So, for example, if you were in a court of law trying to prove that this munition caused this damage, it's going to be very difficult. There was a lot of talk about economic drivers today, and so I'm a little nervous about putting this slide up now because there were so many diverse opinions, but it's up there anyway. And one of the ideas that I've come across is a bounty on munitions. I don't know exactly where that money would come from at the moment, but if you somehow created an economic incentive so you had a price tag on each recovered munition, you might actually create a market for this kind of activity. A trust fund, domestically or internationally, could help fund research and also remediation activities. On the international level, such a trust fund could be administered by an international organization, such as the International Maritime Organization, United Nations Environment Program, and even the OPCW, perhaps. Environmental impact statements and government-granted permits. So before you lay a pipeline or you build a wind park or you do an offshore drilling, you need to do an environmental impact statement. This is actually customary international law. This is something that you have to do before these big projects. And then you get the government permit. I personally have not seen these, what are probably documents that are hundreds of pages long, but maybe we're not doing environmental impact statements the right way, and maybe government permits are not being granted the right way. Maybe we only need to be granting these permits if the commercial endeavor is going to be demonstrating that they are going to sincerely remediate those submerged munitions. And going even before that process, when a competitive bidding goes out for tender, and you have these multi-billion-dollar contracts that are granted, in the tender, you could require the bidders to give the plan for remediation. And maybe this is a cost that could be passed on to the commercial sector and then to the end user finally. I heard a question about the wind farm cost will ultimately be passed on to the user of the electricity. I was also very excited to hear about the idea for a pilot program, which is very exciting. And I even heard debates during the break about which site it should be. And these are things I've never heard before, people debating, no, it should be here, no, it should be here. So I do think it's high time for a pilot project. And I think I've heard everyone in this room going in that direction. And all of these can be facilitated by bilateral and regional agreements or sub-regional agreements. And going into my concluding remarks, the thought I want to leave you with is that not only does international law present no legal obstacles, in fact, international law has positive obligations for states and sub-state actors to take action in this area. We don't need any more international legal infrastructure. We certainly do not need some big, complicated, lowest common denominator international treaty. The international law is in place, and now it's time for the necessary domestic law to be put in place if it's not already there, and then for action to be taken. So I say that because I feel like it's my job as the international legal person to tell you we don't need big, long, complicated multilateral processes for a new big instrument. You don't need that to go to implementation and remediation. It's the responsibility of states to engage in remediation, and legal liability for the majority of the past dumping is probably going to be a doubtful prospect. However, I don't think this is necessarily a negative thing. I am of the view, and I'm happy to discuss this, that the absence of liability and the shift of the discourse away from liability onto cooperation could calm down some of the concerns and motivate the stakeholders to feel more comfortable in moving forward with remediation projects. Economic drivers could be important, and thus far the norm has been to leave the munitions under the waters, and all of the work that's being done, I'm very hopeful that it's going to create a new path dependence whereby the new norm will be cleaning up the munitions and fixing the mistakes of our collective past. Thank you very much for your attention.
Thank you so much, Grant, for your very inspiring presentation. And as I told you, we're about to climb down the tree of the hierarchy of law from the international level to the domestic level. And on the German territory, there are two levels, two layers of law, which is the federal law based in Berlin, so the law of the Federal Republic of Germany. And then there are 16 Bundesländer with their own domestic law. And between these, the German constitution provides a system of shared competences between those layers. And it's interesting to see and to also see the blame game between the federal state and the Länder, who really has a responsibility for dealing with ordnance clearance. And at the moment, and I think Mark will go into detail of this, the general standpoint is that the Länder have the responsibility for ordnance clearing. But that doesn't mean that the state, the federal state, is prohibited from doing anything. So the Constitution provides, in Article 74, number 9, federal competence for war damage. Number 20, the law on food, including food-producing animals, animal protection and protection of plants. Number 21, shipping law. Number 29, nature conservation. All these are fields where the federal government or the federal parliament could act. But they didn't, or they did in part, but not completely. And Mark Wernicke, our expert on domestic law and a practitioner in ordnance clearing, will talk about these details in his presentation. Mark worked between 2005 and 2013 for the Federal State Bureau investing in explosive crimes. He earned a master's degree at the Berlin School of Economics and Law and now serves the Explosive Ordnance Disposal Office of Schleswig-Holstein, where his main task is to oversee infrastructure projects on and offshore, and since 2021, he also is the deputy head of his unit. Please applause for Mark Wernicke, our next expert on the domestic legal affairs. Mark, the floor is yours. I'm happy to have you here.
Thank you, Moritz. I will have my presentation and we'll try very hard to speak as fluent as Grant did. However, my English is slightly worse, and my notes are gone. I see. Okay, is there a possibility to get my note to make my notes visible? Then I have to make it up. Great, and and I put in some links in the slides, and I have to activate them during the presentation. Is that possible? So now you already see my presentation, so it's not that exciting anymore. Or maybe I will work it out somehow. Just keep it that way. Yeah. Okay. Welcome again on behalf of the EOD unit of the state of Schleswig-Holstein. As Moritz already said, I'm trying to present the domestic law. I'm focusing on the federal state of Schleswig-Holstein because that's what I know best, but I try to consider the other coastal states as well. What you can see on this very first slide is our area of responsibility, and you can see we have some shares on the North and Baltic Sea. Yeah. When it comes to ammunition dumping, we are privileged. Okay. And as Moritz already said, I'm trying to show you. I will have some slides on the domestic law, but I'm also trying to show you some examples. What's the state of the art of ammunition disposal? I sense it might be illegal, but we'll see. Okay, you already know about the coastal waters. Is anyone not aware of coastal waters and the zones? I just sum up. It's up to 12 nautical miles. However, we would interfere with our neighbors if it has the whole range. So it's you can. I have a map with me, so I can show you the two zones we are talking about, and the two zones who are polluted with ammunition. One is the coastal waters, and as far as I know, there's the main pollution located in these coastal waters, by far. Anyone of the audience knows how many dumping areas? It's about 129, and more than 100 have been located in the coastal waters. So here's the main problem. And there are also some problems in the exclusive economic zone, some dumping areas, but not that much. But I'd like to distinguish between these two zones, because the coastal waters are the territory of the federal states, like Schleswig-Holstein, and the exclusive economic zone, as you already know, or most of you already know, are territory of the Federal Republic of Germany. So there are two different responsibilities which I like to present to you. And I just mentioned there are two responsibilities, and however, it is necessary to mention that the responsibilities are depending on the protected good. One good that my unit is responsible for is security. And when we are talking about ammunition dumping and clearance of ammunition, in the most cases it is marine environment pollution, and this is another protected good, as I called it. And there are so the responsibilities on the federal state level, but also on the federal republican level, they focus on security, and this might be a problem. However, there is it has to be mentioned, and I will sum up with that later on, but just keep it in mind. And these are, you already know the map from the sessions earlier, but is there any map when I point my laser on it? Does anyone see it? No? Okay. I'm talking about the coastal waters are, of course, they're close to the coast, but I'm also talking about the EEZ, I just mentioned, and that is the zone between these. The German EEZ is the zone between these black lines, and there are some different responsibilities, as I said. And there's also a difference in the structures and the authority structures on the federal state level and on the federal republican level. I'm representing an EOD unit. Every coastal state or every federal state in Germany has an EOD unit. Some of them well equipped, some others not that much. But in most of the coastal states are quite equipped, and but there's no steady structure or permanent structure on the federal republican level. That means, of course, for example, the Navy, the German Navy, they have some experience with clearance, but there's not a permanent unit that has to deal with this problem and has its own experts and its own technique and foremost its own regulation. In the coastal states, there is a regulation that is in Mecklenburg, West Pomerania, and in Schleswig-Holstein, in Lower in Hamburg, and in Bremen. It's the same. There's an own regulation made by the Ministry of the Interior, or however the ministry is called in these federal states, and it's slightly different in Lower Saxony. But altogether, there is a responsibility and a unit that is responsible for munition clearance, and this is the main difference on the Republican to the Republic level of Germany. And so, to sum up, in coastal waters, there's no spatial limitation. That means we are responsible for all of the coastal waters except the shipping routes, because they are covered by all over German law. But as I already mentioned, the federal states and the EOD units, as part of the Ministry of the Interior, are focusing on public security, not on marine environmental issues. And that's the same. There's a similar thinking and a similar law on the. Now I don't see anything. There's a similar structure on the federal republican law that focuses on the shipping routes. Which means, as I already said, and to sum up, we focusing on public security when it comes to ammunition, and we just look on ammunition whether it represents a risk, for example, to shipping or to human health, or not. And this is the status quo of the domestic legal system. And so, to drive a conclusion, it is, from my perspective, it is necessary to create a legal basic for systematic munition clearance. And I'm happy to help with that. If I cannot be of any help, I'm happy to do so. And this is my main intention, to just to offer my help, because right now there might be a legal problem. And I was asked to close this part of my presentation. I was asked also to provide some impressions of our daily work, and this will be my second part of the presentation. So I would skip over to the next slide, where I show you the working of our EUD unit. And I marked these. Okay, no, it's gone again. I marked these spots on my presentation we are talking about today. Of course, we're talking about water areas, no surprise. But what I like to show you is how our diver unit, that is part of our EUD unit, is doing their identification of dumped ammunition. And I also try to, I will also show you some examples of disposal. But just keep in mind, this is the status quo. It's not legally observed, and it's not the final conclusion. You already heard about technical measures that might be better, but just have an impression. Now I have to activate these links, and we start with diving operation at the Baltic Sea with a 1 in the brackets. Is it possible to activate it? Otherwise it would be a very, very short presentation. No. No. Don't show my whole presentation, please. When you just click on this diving operation.
Bracket 4, 1, bracket 1.
Yeah, bracket 1. Yeah, that looks good. It will. Just yeah, okay. Well, it's German. The text is German, but if there are any questions, I can explain it later on. Okay, there should be a sound. No sound. Okay, it's no problem. I just can explain it. Well, here's an object that is that should be a British ground mine, and the diver, you just have an impression how it looks like. And I'd like to show these images to you because it's quite hard when you think of technique that has to do the identification instead of the diver, who is, as you can see, who's using his hand. It's for identification. He's looking for some holes in the body of the mine to find find out whether there is a fuse or not contained. And this has to be done with technique, just to keep in mind. Okay, that's enough. And when you try to go back to this slide where you where all these links, you just have to click on this little symbol on the right corner. Okay, now we can go on with the diving operation at the Baltic Sea with the 2 in the brackets. And this is a German torpedo mine, you will see, or just some parts of the German torpedo mine. And what you can see here is what I just described on the earlier video. Here are some holes in it, and this is where the fuses, 3 of them, should be in, and this is quite easy to identify because you can see there's no fuse in it, so the danger is quite low. Okay, it's okay. You don't have to see the whole video. Won't change. Well, and now I like to show you the blasting of a British mine low order at first. And I think you can just skip to that's perfect. To the next slide. What you can see here is a British ground mine. Don't ask me about the mark. I think it's Mark 4, but there are different models of them, but they work the same. It's okay when I show you the working of our unit on this drawing. And what you can see here is on this photo on the little photo where I wrote sharp charge. This is how we work. We try to cut off the ignition unit, that is the fuse of the ground mine, and then take the rest of the body where the booster charge and the main charge is included. The main charge is about 300 kilograms in each ground mine. It's pretty heavy. I'll show you another video when we are not able to clear that way. What we try is to cut it off, the ignition fuse, and then take this main charge and drive it to a dumping area. This is redumping, as you said, or dump it again, and this is the only way to get to clear, for example, a shipping route right now. There's no possibility because of the danger of the booster charge to do it in another way right now. And maybe you on the next video you will just choose the low order link, and then the next video. Skip to the next slide. Yeah. Now there should be. It would help to have a sound, but now there would be a little sound. I have to describe it for you, and that's all. You just see water. That's how it works. And now we have I will show you a different method that we try to avoid, and this is another ground mine. Just choose the symbol on the right corner to go back to the slide. And now I show you the blasting of a British ground mine in the harbor of Kiel. Now you can choose high order. We don't need the sound. It's impressive, still impressive without sound. And what you can see is there's quite big destruction on the ground of the sea, and there was the quite high damage. There was a mussel farm. You just heard about. You just talked about aquacultures. This is an example. There was an aquaculture, and that was destroyed, unfortunately. And this is why we try to avoid it. There's a real big impact, and it's of course it has a bad influence on the marine environment, and but in some ways, and this was some years ago already, there was no other option because it was a quite dangerous ground mine. The fuse was in a very bad shape. And we had no other option than to get it out and to do it that way, to blast it in a high order. Today we try to have some measures to get the negative impact quite low. For example, a curtain made of bubbles and maybe you already heard about it, but there are some measures we try to take, but in some cases it's not possible, but we try to avoid it. Okay, then we can skip to the next slides. Just skip through the videos, and there should be. All right. Here you have some impressions of the ammunition coming out of the sea. Just focus on the two images on the top, on the right side. You can see it's very hard to identify these ammunition, and it's we have some experts who are capable to do so, but it's quite hard. And I'm really excited about experiencing the techniques that are able to do it, that could identify these objects and even more evaluate the risk coming out of this object. And I'd like to give you an impression how they look like. It's for me it's not possible, but some of my colleagues, for them it's quite easy. They say, well, it's obvious what you have in your hand. For me, not. Okay. Then we go to the next slide. This is just give you a short impression of our technical improvement on our unit. This is a system that is made or created or established by North IU. It's the gold partner. Is it a gold partner? Okay. Of this event, and also involved in establishing this system in our unit. And our main focus is to combine these different historic information. On the next slide, and which will be my almost last slide, you have an idea. You get an idea of spatial data that have been connected. These are all information about ammunition, but onshore, and we try to get better on the offshore part, and that's where we're working on. And I think it's crucial to develop our system in that way to get more information about the offshore part. Okay, that's all from my part, and I on the next slide there's just a contact of mine, but I think you will get the contact information out of this event. So thank you for your attention, and I'm ready for discussion.
Thank you so much, Mark, for this impressive visualization of your practical work. Some days ago, I talked with an old lady from Holtenau who experienced this high explosion and says the whole quarter was shaking when you exploded this old mine. So this is really a blast. And as I sat just in front of the TV screen, I was pretty happy that the sound was disabled. So before we come to your questions, and to the question of the online audience, I would like to pose an icebreaker question to the both of you. Just imagine if you were king of the Baltic Sea. Which legal rules would you change or like to have imposed? Mark, maybe we start with you.
Me first?
Yes, you first. As you said, you're unhappy with the law at the moment, and Grant appeared to be more happy with it, so he might need some time to think about a rule which he likes to have imposed. But Mark, please.
If it was up to a king, then I would create a regulation that addresses the environmental aspects of the Baltic Sea, and to combine the ecological and economic use of the sea. And I think there's a lack right now. This would be my action.
So what about you, Grant?
You took the words right out of my mouth. Oh. And combining the environmental with the economic, I mean, That's exactly what I would do as king of the Baltic. Do I get to be king of all the coastal states also?
Yes.
Okay. Wow, I can do a lot more than just that. No, but and perhaps the only only thing I would add to this is a multinational enforcement authority, which is well resourced and can actually impose sanctions upon actors that are not complying with the regulations.
Thank you very much. So now the microphone is placed behind the camera. So if any one of you has any question to our qualified experts, please feel free. Professor Jenisch is standing right in front of the microphone, so the floor is yours.
Thanks a lot to both speakers for adding so many detailed information. And I just want to add and direct your attention to another piece of information. Changing the legal rules was your proposal. And if we look into the federal basic law, there is Article 120. And this article regulates the costs of the occupation forces after 1945 and the costs of World War II leftovers. But in the second sentence it said, all this subject to special federal laws. So in the period after the Second World War, laws were passed in Bonn and Berlin to finance the occupation forces in Germany and so on. But a special law for regulating leftovers of ammunition in the sea or on land was missing. In the second chamber, the Bundesrat, the North German Länder tried several times since 20 or 30 years to start a new law which they called Rüstungsaltlastenfinanzierungsgesetz, which means in English financing of military leftovers. And the content of this law would be that the federation, the Berlin government, would pay for the leftovers. This law has been tabled in the second chamber, in the Bundesrat, for the first time in 1992, which is nearly 30 years ago. And it has been repeated in different periods later on. It has been blocked off by the other Länder, because it was a proposal by the 3 North German Länder. So the 13 other Länder blocked it off, and of course the Federation blocked it off. So this clause, this Article 120 in the federal law, in the federal basic law, could be leverage to change the legal rules which you just proposed. Thank you.
Thank you very much, Professor Jenisch, for this additional piece of information, which was really interesting and goes much into details of the constitutional law. I suggest that your information wasn't combined with a question, so I think there is no need of the 2 speakers to comment on this. So that's why I would like to continue with the questions, or maybe with some other interesting remarks from the audience.
Yes, Sven Kuczynski. I'm a consultant and a biologist. So when biologists talk about law, it's maybe the same when lawyers talk about biology. As we are going to vote later this month, I'm quite unhappy that I can't vote for the King of the Baltic. But I'm happy that you both mentioned that the nature conservation law would be needed, which can be applied to this problem of old munitions. When I looked at your presentation, Mark, with the high order blast, it's quite obvious that this is not good for the environment. And in your presentation, I'm kind of missing the current laws which deal with nature conservation, namely Habitats Directive of the EU and German Bundesnaturschutzgesetz. Can you reflect a bit on that, please?
Well, I left them out because they're not focusing on ammunition disposal. I just looked on ammunition disposal and what is the legal base of this subject. And of course, I know the laws you mentioned interfere, or our measures interfere with the laws. But I focused on the duty, and that's why I presented the law we are working. That is our basis of work.
Thank you very much. I think as this is a domestic question, maybe you want to say something about the European Union aspect, which was mentioned with the Flora for the Habitat Directive. Do you know about the European Union dealing with this topic, Grant?
Well, I'm not an expert in EU law, but I can tell you from the international law perspective, and thank you for the question. If you look at the United Nations General Assembly has passed more than one resolution in the disarmament field, and I see this as it could be looked at as a disarmament issue as well as an environmental law issue. The General Assembly said that all disarmament agreements and activities need to mainstream into themselves environmental considerations. And what that means is when you're blowing stuff up, you have to protect the environment at the same time. Of course, there's some tension there, and you're going to have to balance the need to get rid of a very destructive, dangerous munition with protecting the environment. You probably can't get away with completely not touching the environment. But the Chemical Weapons Convention has very strong norms embedded into it that the environment is to be accorded the highest priority during destruction of chemical weapons. And when the OPCW verified the destruction of old chemical weapons in San Jose Island in Panama, the documents that went before the Executive Council for approval had very clear statements about how the Panamanian local environmental regulations were going to be complied with during the destruction of the old chemical weapons. So it's always going to be a balance, but from the international law perspective, and I think from many domestic law perspectives, you don't have carte blanche to do whatever you want to the environment in order to destroy these munitions.
Thank you very much. So when Mark is active in destroying mines or disposing of mines, he is relying on the lender competence to take care for security issues. Besides that, the federal state has the competences, as comes clear by this national law on environmental protection. The federal state could enact some law, could legislate some law, which has an overall, which covers an overall perspective, and using this competence for an environmental protection to have some kind of munition clearance law. There would be the legal competence according to the German Constitution, for example, for environmental issues, as we are dealing here with this topic which has issues of security, obviously, but also has issues of environmental protections. But the next question is ready. The next questioner, so please.
Thank you very much. My name is Hans Sanderson. I'm from Aarhus University, and I have a question to Grant. I was wondering about the precautionary principle you mentioned. Is that really part of international customary law? Because, I mean, most countries like US, for instance, you cannot, use that. And in the European Union, we came out with a white paper, basically in 2000, that looked at operationalizing Article 15 from the Rio Declaration, which is the formulation of the precautionary principle you cited, simply because it's not operational. So I was wondering which of those two are in charge, basically, in Europe. Is it the white paper, or is it this Article 15? And is it actually operational in any way in this regard?
Thank you for that question. And you talking about the precautionary principle, right?
Correct.
Yeah. So I like the word that you use, that it's not operational. I would use a different word. I would say it's not complied with. The precautionary principle is indeed a customary international law principle of an international environmental law. It is there, it applies, it's binding on all states. It doesn't mean it's always complied with. And that is the difficulty oftentimes, not only with international law, but with domestic law. You have the law on the books, and then you have real life. And that is one of the reasons why in recent years, I think there's been a very good trend in environmental circles away from promulgating new laws or contributing to the fragmentation of international environmental law, and the focus has been more on implementation. And I think this is, in some ways, more difficult. And the legal scholars, they love their laws, they love their treaties, they love their beautiful pieces of paper, and they consider their job is done when the law is written. But the job is not done. The job hasn't even started. You simply have the principles, and now you have to apply them. So to answer your question, yes, precautionary principle is there, it's binding, and part of our job is to make sure that our governments follow it.
Thank you very much. So now I would like not to forget our online audience. Do we have questions from the online audience? No question from the online audience. So the next question is ready to be asked. Thank you very much.
Thank you very much. Thorsten Frey from Geomar. I have a question, maybe Grant, if you know anything about this, because I think according to the Geneva Convention, landmines are of course banned, and countries are supposed to remove both the stockpiles that they may have of landmines and landmines that are in the field. And also this is true for cluster ammunitions. And we know that landmines were dumped in the dump sites that we have in Germany. So do you think that might be one way to leverage the clearance of dump sites, because there are in fact landmines lying in these dump sites?
Well, it's interesting that you bring up the Geneva Conventions, because you mentioned cluster munitions, and we have an international instrument on cluster munitions. And you also mentioned landmines, and we have a landmine convention. So my instinct would be to look to those instruments in the first instance, which has a lot of obligations for both the territorial state where the munitions are located, and also the state that ultimately is responsible for putting them there. So I would look to those two conventions. As far as the Geneva Conventions go, I mean, these are conventions that were adopted shortly after World War II, and they mainly have to do with the conduct of the parties during and armed conflict. And not any armed conflict. That regulates the conduct of hostilities during an international armed conflict. And all four of the Geneva Conventions have common Article 3, which regulates the conduct of parties during both international and internal armed conflict. So I think we would want to look to the Landmine Convention and the Cluster Munitions Convention, and I think you would have plenty of obligations in those two instruments. We would also have to see whether the relevant state parties have ratified those instruments.
Thank you. I think you want to ask the next question.
Yes, if I may.
Yes, sure. Go ahead.
Thank you. My question is regarding the Chemical Weapons Convention, and if we have a fisherman catching a mustard gas bomb off Bornholm, brings it to the harbor, and the authorities have to deal with that. It's common practice to redump the mustard gas bomb, and I sense from what you said before, there's no redumping, this is dumping. And how does this, how can this law be filled with life? Is there any way of enforcement, or how do we as the community dealing with munitions can bring things forward?
I'm very impressed with this question. You've hit on a critical issue in respect of the chemical munitions, and this would only apply to the chemical munitions, of course. So in Article 3 of the Chemical Weapons Convention and in Article 4 of the same instrument, shortly before, at the last minute of the negotiations, which spanned decades, there was an exemption put into the Chemical Weapons Convention for any munition dumped into the ocean before 1985. States did not have an obligation to declare that chemical weapon and to destroy it. So anything before 1985 gets a free pass. You may declare it and destroy it, but you do not have an obligation to do so under the Chemical Weapons Convention. There are other obligations that I spoke about during my presentation that would apply. Now, this applies to munitions that were buried on land before 1977 and munitions that were dumped in the ocean before 1985. And the question has arisen, and it's been hotly debated, what happens if you raise that munition to the surface, as you posited in your question? And the weight of scholarly authority and of institutional authority states that if you raise that munition to the surface and it's no longer submerged, it becomes declarable under the Chemical Weapons Convention, and you have to destroy it under international verification by the Secretariat of the Organization for the Prohibition of Chemical Weapons. So the weight of scholarly authority says if you raise that munition and you have it above the water, you should call up the German National Authority, which is designated as the liaison between the state of Germany and OPCW, and OPCW will send someone and will verify how you're going to destroy that munition under international verification, giving the highest priority to the protection of the environment and the safety of people.
Thank you very much for this insight, Grant. And there are now two people approaching the microphone. No, just one.
Yeah.
So please, the floor is yours.
Okay, yeah, Jens Greinert, I have a very quick question to what you just said. If you bring the chemical munition not above the waterline, if you keep it in the water in 10 meters depth and you go with your little rubber dinghy 3 miles and you drop it, what's then?
From a legal perspective,
You should become lawyer.
from a legal perspective, it's a theoretical example, I hope so. That wouldn't never happen. But if you keep it below the waterline, from a strict legal standpoint, it's not declarable, and yeah. But I don't know why you would do that. Bring it, just leave it there. But there you go. That's one of the, sometimes the law, yeah.
Maybe it could be changed, the law, that as soon as you lift it off the ground, yeah. Okay.
So before we go to the next question, I would raise another topic concerning Mark's practical work, inspecting and observing private entities' activities in the sea, and building structures like pipelines, like offshore wind parks, and so on. And we were discussing in advance the responsibility of these private entities. And you were also talking, Grant, about just redumping and putting the ammunition to the side. And I'm wondering if we have this, our private entities responsible wouldn't that be a deterrent for those entities to engage in any marine activity? For example, if we have a look at the eastern side of the Kiel Fjord, there's a beautiful forest there, and people wonder why is there forest instead of luxury apartments, office buildings, and so on. Well, the reason is that not all ammunition has been dumped in the sea. Some has also been dumped or at least left on the ground where the old Kiel shipyards were in the Second World War. So this territory basically is too expensive, or the risk of finding ammunition is too expensive for private investors. So what about this problem, Mark? Private investors, private initiatives, should they be responsible for the ammunition they find? How would you deal with this subject? Or how do you deal nowadays with it?
I think we have to, what you just described, this is an onshore problem, right?
This is an onshore problem, but as marine activities increase, people are willing to build offshore wind parks and pipelines or mussel farms, fish farms, whatsoever. This might be a deterrent for them not to engage in any marine activity. And I mean, this is also a goal of the German government in order to fight climate change, to increase the amount of offshore wind parks. So,
well, I can tell you about the regulation, how it works onshore.
Yes.
That's currently the owner of the estate is responsible for not harming or creating any danger to the public security out of his estate. And that's why he is responsible for disposal, or at least he pays for it.
Okay.
This is the situation onshore. Offshore, it's not that easy, because it's on onshore we have an owner, and offshore it's quite hard to say who is the owner. And if there this is now I'm talking about experience from former projects, and there the disposal was paid and done by companies and paid by the project owner. For example, if there was a wind farm that was built, then the owner of the wind farm, or the enterprise that likes to build the wind farm, paid for it. Or another example is the tunnel that should be built between Denmark and Germany, and it's the same way. And the authorities on the federal state level, but also on the Federal Republic level, they say you like to build a tunnel, so this is your problem. You have to pay for it, and you have to organize the disposal. This is how it works right now.
So in the private entities, they approach you as a Kampfmittelräumdienst in order to get the dirty work done.
If they find ammunition, of course, we are involved. But all the measures before identification and final disposal are done by companies and paid by the project owner.
All right, thank you. Are there any further questions? Maybe, yes, Professor Jenisch, again.
Again, a little remark. One of the great qualities of our Danish neighbors is that they are very pragmatic. And as regards redumping of munitions caught by fishermen, they have an incentive program that fishermen can deliver these munitions at the island of Bornholm and get a financial premium for that. Money is a solution.
Thank you very much. Do we have questions from the online audience? Not yet. No question from the online audience. And there is a question from our present audience? Yes.
Sorry about that. Since I'm from Denmark, I just want to pick up on Femern and also the redumping. So in Denmark, if there's a fisherman who catches any munition, he calls the Marine, and they come and check it out. If there's any explosives in it, they bring it, then they redump it. If there's no explosives in it, they bring it in and stockpile it and then incinerate it. But it's too dangerous to bring in, halfly corroded bombs. There's 1.5 kilo of TNT in these mustard gas bombs. So that's basically the procedure, and it's been like that since the 60s. But I was wondering, Mark, about the presence of munitions in connection with the Fehmarn Belt connection. Is that something that you have experienced? Is that an issue in Germany? It's not an issue in Denmark. And then what's the future of that landscape with munitions and in regards to getting that connection put in place, do you think?
Well, I'm not quite sure whether there's an issue or not, but I know there was a discussion who's responsible for the clearance, not in the coastal waters, as I already mentioned in my presentation, but in the EEZ. And when it comes to the German EEZ, there was a real discussion, and it was solved the way I already mentioned, that the project owner, the company that built the tunnel, did the disposal by involving our unit, and this is how it worked. I don't think there was really a problem, at least at the German side. I only can speak for the German side, of course. I know there was some. But most of the ammunition that was found was on the German side, in the German EEZ. There was only, I think, 2 or 3 items on the Danish side. I don't know exactly how they have been handled, but I know that on the German side we worked together with the company, and identification was done with the help of technique of the company, but also with our help, and then we took it off the sea and finally disposed it on the entity that is responsible for it.
Thank you very much. So I'm happy that it appears that we have some online questions, and 3 minutes left. So I would be grateful for quick posing of online questions and then very quick answers.
Yeah, there is a suggestion to just develop or further develop our German basic law to solve these problems. And there is a direct question to Professor Jenisch, and I will discuss it bilaterally. The other question, and that goes to Mark Wernicke, is what is the problem for the state government to increase the capacity of Kampfmittelräumdienst to just deal with these larger amounts? Legally, it should be possible. It's not my question, it comes from online.
But could be yours. Well, if we have a legal base and if we have the money, I think a lot is possible. But let's be serious. I think the main problem is the final disposal and the capacities we have. Because I think it's not easy, but it's realistic to have a technique to get the ammunition out of the sea. But I'd like to combine and think of all the 3 steps that are relevant in this case. And the first step from my perspective is to exactly know what we are dealing with. What kind of ammunition, what amount of ammunition, what sort, whether it's fused or not, then have a really reliable technique to get it out, and then, and this for me, this is the real problem, is finally dispose it, and have the capacities to dispose it. And we are far away from any realistic disposal capacity we need to get this ammunition, these 1.6 billion tons out of the sea, and this is why I see just a practical problem.
Thank you very much. And we're approaching the end of this panel, which came much too quickly, but gave a lot of inspiration for you to think about issues which can be done. And if you leave this panel, this session, you should go out and keep Grant's remarks in mind that international law doesn't stand in the way of getting active. And the same is true for the German constitutional law, which also doesn't stand in the way for the legislature to get active, to create some some general law on the destruction or disposal of ammunition. And it should be done, it can be done, and I'm sure as we leave this conference at the end of the week, it will be done. Thank you very much. Thank you very much, both of you, for your presentation and your insights on your practical works and your scholarly experience. And thank you very much for listening and posing interesting questions. And we are now having a technology showcase at 5:45, so just now, and you're very welcome to watch this technology showcase as well. Thank you very much.